But I have questions for the panel. Don't move. Chairman's got one question. Okay. And so I want the people in the audience to know if you filled out a white card, you are going to get to come to the table. I don't want you to think you're not. I just had to get the question part of it over since some of our members had some scheduling conflicts and they had to leave and they wanted to be here to ask questions. Okay, my question is this. The district attorneys across the state, I know at least in the state of Louisiana, the death penalty is not mandatory if it meets a certain factual criteria. It is discretionary with the district attorney. And I guess I'll ask, the Attorney General as well as Mr. Stingfield. I'm sorry. Almost lunch. Of the amount of crimes that are committed that could be fit the death penalty criteria, okay? Do you have any information or any opinion on district attorneys or numbers or ratios versus I could go for the death penalty, I'm not. These are the number of death penalties cases that have been going forward. And the point I'm trying to make is that I'm assuming that if you are a district attorney in a district and one of these crimes have been committed, that there are situations where there is mental illness or something to that effect that you take in consideration. But the cases that are being prosecuted on a death penalty situation cannot be an easy task. The district attorney, he or she knows that, and this would have to be the most heinous of the heinous in order for a district attorney to undertake this. And I would like to get the panel's opinion on that.
Yeah, I think look, part of why we're here today is to discuss how to get the executions back on track, right? Because again, if there's a law in the books and we're not willing to uphold that law, then the system starts to break down. One of the things that DAs, and I just left their conference that they were having, came back from there yesterday, we discussed it, is that the failure for us to perform the executions is creating a chilling effect inside of those district attorneys' offices as to whether or not they're going to seek the death penalty. The ability, and I think Mr. Singfield can speak to this, is the ability of the district attorneys to have that available to them, knowing what the defendant does, even in those heinous crimes. And it's not so black and white, because again, what you don't see behind the scenes is the constant work that these prosecutors do in working with victims' families to determine what exactly the family views as justice. But if you take away the death penalty, if you don't perform the executions, the ability for the district attorneys to actually do that becomes skewed. And so a long way around is we don't have that data because we haven't performed the executions. We know one thing, there is, in talking to the district attorneys, there has been an effect on the judicial system by us not performing the executions. That is a fact. Until we start moving the executions forward, or there's some clarity in the law, the ability to answer that question, I think, is going to be difficult.
Well, the death penalty, what I've seen, is mostly now reserved for those very special people, very special cases. These people that just decide they want to kill 4 or 5 people for no reason. They're angry. They're vindictive. They don't have serious mental problems or whatever. They just make a decision to kill people. And then again, you have these aggravated situations where young children are raped or murdered or killed. You have situations where you have violent armed robberies and executions. These cases, as I've followed now, the district attorneys normally reserve death penalty prosecutions for very special cases where there's absolutely certainty that the defendant did it. They don't try circumstantial cases anymore in death penalty. And where the defendant is of the right age, he has to be over 18. He can't have any serious mental problems, such qualifies him for retardation. And in those cases, you have to prosecute those cases as a standard for an office to show that murders, that you simply can't do these monstrous things and wind up in general population at Angola enjoying your life.
And that and the fact that it's widely known that it takes 15, 20, sometimes over 20 years to even getting close to the execution of the death penalty sentence that a jury gave has got to play a factor in the thought process of the defendant. And
it does. I told some jurors after a death penalty verdict was returned. I forgot. I guess I was 58 or 60 maybe, and the defendant was 36. I told him, actually, you put us on an actuarial table, he's supposed to outlive me. Because of my age, I'm not supposed to be alive at 90 years of age, and he's supposed to still be here. He's 36. But I can tell you in those situations, those length of terms, I've been through 3 of them and had 3 people executed, so it can be done. I have a 4th right now, if they get the drug protocol right, that's ready to be executed. So I've been through 4 of them, the entire system. There are a lot of people, it's a period of time, but during that period of time, sometimes you can have a year that nothing happens. You can have months that nothing happens other than you attend status hearings and you get status hearings reset. And a lot of it occurs in the federal courts. The federal had the Safe Streets and Effective Death Penalty, actually supported and signed into law by President Bill Clinton, who had campaigned on the basis that he supported the death penalty. So there has been a federal effort to speed it up. But it's a tragedy. Like me, I tried Todd Wesker in 1997. I've been to 18 hearings. I argued every one of them except the last one. Dale Lee from the district attorney's office did a very effective job. I've been through federal hearings. I've been through federal arguments since 1997. And then you get here with this family member, and then all of a sudden, I'm told we don't have the drugs to execute him when they're doing it all over the country. That's unacceptable to me. That needs to be corrected.
And I think that was the purpose of the hearing today. I know and just to be candid, on top of the table, the conversation that I had with the Attorney General was that we need to, the real question is why. I mean, the law, as Professor Getty outlined, I think very eloquently, is that the law today in Louisiana is it's legal for the Department of Corrections to, when someone receives a death penalty sentence, to execute that sentence. That is the law today. It's not changed. And I think the question for victims is why? And why is it taking so long? And that was really the purpose of the hearing and the purpose that the Attorney General wanted to come to light. And so I thank everyone. I thank the panel.